Good afternoon, please be seated. Welcome to the First Court of Appeals. I'm serving as panel chief today. I'm Justice Amy Guerra. To my right, we have Justice Kristen Guinea and Justice Andrew Johnson on my left. And we have one case on the docket this afternoon, case number 0124000730 Padmanee Sharma versus Jamie Lynn. May we please have announcements starting with Appellant's counsel?
Michael Perez-Melgadillo on behalf of the appellant.
Jacob Hadgis on behalf of the appellee.
Thank you. Each side will have 20 minutes for argument. I understand the appellant has reserved 5 minutes for rebuttal. Is that correct?
That is correct.
Great, thank you. All right, and I'm sure that you all are familiar with this, but just so you remember, the lights green means continue, yellow means you have 1 minute left, and red means stop. Of course, if you're in the middle of answering a question from the panel, feel free to continue. And with that said, we're ready to proceed with arguments from the appellant.
Good afternoon, and may it please the court. The appellant, Dr. Padmanee Sharma, is entitled to dismissal of each of the claims asserted against her by the appellee, Dr. Jamie Lynn. This is because Dr. Sharma was acting in the general scope of her employment as a researcher with MD Anderson in relation to all the alleged conduct about which the appellee is complaining. Therefore, Dr. Sharma retains immunity to these claims pursuant to 101.106F of the Texas Tort Claims Act. As a preliminary matter, those pending claims are for defamation, libel, slander, and declaratory judgment concerning authorship of one of the two MD Anderson manuscripts.
Well, I have a question about that, because I know that during the hearing, your counsel or someone else with his firm said that the conversion and theft claims, they're not seeking them, or they agree that they're dismissed or something, but no non-suit or no dismissal was ever filed. So aren't those actually live claims still?
Based on the concession at the hearing, we believe they're not technically live. Specifically, the appellee conceded that Dr. Sharma was in the course and scope of her employment as to those claims. So we don't believe there's any legal dispute about dismissal for those claims, but to the extent the court considered them still live, the same argument applies. All the alleged conduct, whether speech or the attribution, the authorship of that 2022 manuscript that formed the basis of the conversion and theft claims, are in her general scope of employment. So, as mentioned, appellee has raised 4 different issues, legal issues, in response to dismissal. We believe that this court and the Supreme Court's precedent is very clear as to most of those legal issues, so the focus of our argument today is going to go to the general scope of employment question, unless, of course, the court has questions regarding the other issues.
Yes, I think we have a question about, just assuming, for purposes of this argument, that we agree with you on the tort claims, then what about the declaratory judgment action?
Certainly. Under the UDJA does not enlarge trial courts' existing jurisdiction outside of the very few narrow topics which aren't in place here concerning ordinances, statutes, contracts. So here the very nature of the claims against Dr. Sharma all sound in tort. And that includes the authorship attribution that they were seeking, and which in fact was originally the basis of the conversion theft claims. If Dr. Sharma, if the court agrees that Dr. Sharma is entitled to dismissal of all the tort claims against her, the nature of the declaratory judgment, which is also tort, the trial court wouldn't have jurisdiction over that issue.
How does the declaratory relief sound in tort when she's asking for herself to be designated as the senior and corresponding author, and for Dr. Sharma to be, have no authorship? How does that sound in tort? That, to me, sounds like a declaration.
It's a declaration concerning a property interest over which there's no dispute that there is no property interest. As was conceded at the trial court and on appeal, The intellectual property underlining Appley's allegations is the property of UT system managed by the university, Regents Rule 90101. That forms the basis or ties directly to her authorship dispute here. I would point the court to the Sawyer Trust case as well as I.T. Davey. Those two Supreme Court cases dealt with jurisdictional questions involving government type claims. And there the Supreme Court counseled, one looks to the true nature, the substance of the allegations, and if there's not jurisdiction over that substance, tort, there's not jurisdiction to afford the declaratory relief either.
Would that be a dismissal then still under F, or would that be just a separate, there's no subject matter jurisdiction type dismissal? Does that make sense?
It does, Your Honor. We don't know that there's a meaningful distinction because the F itself is a jurisdictional motion. We pursued the dismissal of the UDJA claim also pursuant to the F. And so if the tort claims go away under F, so does tort-like claims that Appley attempts to bring under a different mechanism. So returning to what we believe might be the real dispute in this case, which is general scope of employment, the legal question for that before this court is as follows. Is there a connection between Dr. Sharma's communications concerning attribution for herself and colleagues Drs. Diab and Abu Daye and her employment, now over 20 years with MD Anderson, as a researcher? We contend the answer is yes, based on the relevant legal analysis and the jurisdictional evidence pending before the court. I would first direct the court to this court's prior decision in Fink v. Anderson. There, this court concluded that a UT Austin professor's speech, which was alleged to have been fraudulent by the plaintiff in that case, was within the general scope of his employment, and therefore all the claims against him were subject to dismissal, even if the plaintiff had been correct about the alleged nature of the allegations. In reaching that conclusion, this court, in addition to looking at the year prior's Alexander decision from the Supreme Court, noted the Alexander case relied on the restatement third of agency, 707 sub 2. That presents a negative definition of scope of employment. If an employee's conduct serves no purpose of their employer, they're not in the scope of their employment. This presents an objective test for the court to look at. The 2 years following that, in the Lavery v. Weatherby decision, Supreme Court concluded that a Texas Tech senior official was in the general scope of her employment in a case not unlike the one at Barr. The alleged defamation and other intentional torts concerning the colleague of hers at Texas Tech. There, the Supreme Court looked again at the restatement and flipped the test and said that the question is whether the alleged tortious conduct is connected to the employment. And if it's yes, you're in the general scope of employment. So returning to the facts here, the record makes clear that the dispute concerns intellectual property developed by MD Anderson employees on MD Anderson time, the IP of which is ultimately owned by the university and UT system. There's the two manuscripts at issue. So the 2021 manuscript, the record further reflects that Dr. Sharma was a senior corresponding author of that manuscript. When looking at what the university's interest might be in accurate attribution and how an employee advocating for that on behalf of herself or colleagues goes to that interest, I would point out to the record Institutional Research Policy 3535, which is the scientific research policy at MD Anderson. Sections 4.0, 4.1 go to the importance of MD Anderson employees ensuring that the work they do accurately reflects their attribution contribution, and that they also ensure that they give appropriate attribution to other participants in the underlying research. Moreover, Institutional Research Policy 3532 is the scientific publication policy. There, it defines at MD Anderson what the role of a corresponding author is, what their function is. Among other things, a corresponding author, one, ensures that the authorship list is accurate, and two, for anyone who's being given attribution, ensure that their attribution is accurate. Did they do the specimen collection alleged? Did they conduct the data analysis alleged? Did they just review the manuscript? Dr. Sharma, as it's undisputed, was a corresponding author of the 2021 MD Anderson manuscript. So the communications she engaged in November of 21 are entirely consistent with ensuring that she and other people got the attribution that was alleged. Now, the 2022 manuscript that was to be submitted to JCI Insight, when Dr. Sharma learned about that manuscript and discovered that she and her colleagues, Drs. Diab and Abu Daye, weren't listed at all, she also took action to effectuate the university's interests and her colleagues' interests in being credited for work that they did. Again, this is consistent with MD Anderson's interest in the underlying research. Moreover, it ultimately resulted in MD Anderson, in investigating the second incident, agreeing that Dr. Sharma and her colleagues had not been given the attribution for which they were entitled.
I have a question, and obviously this didn't happen here, but is it ever the case that rather than have someone like Dr. Sharma, who is contesting the attribution credits to a third-party publication, that instead of that, authors or alleged author communicating directly with that journal publication, that instead the institution, someone who is not one of the people who is asserting that they should be attributed some credit or authorship, then it should be someone else, from MD Anderson who can communicate and perhaps sort of attenuate the relationship and make it less, acrimonious.
The record before the court, the institutional policies I don't believe address that engagement, but what I can say is Dr. Drayetta, who is the Senior Vice President and Chief Science Officer of MD Anderson, when he reached out to the parties here, he did say that, regarding the 2022 manuscript, he said that if they didn't accept the findings of MD Anderson's investigation, it would be necessary for MD Anderson to communicate those findings to JCI Insight. So there was a contemplation, at least in this instance, that might occur. A week later, Appley submitted a cease and desist letter, and this litigation followed.
And yet, I guess that article remains online with the original authors to this day, correct?
The 2022 one
correct.
is, and as of a month ago when I checked, the hyperlink was still active. So as a final note, Your Honors, as you noted, there was the original conversion and theft claim. The original claim there, whether it's still active or not, was that by arguing about the attribution on the 2022 manuscript, that Dr. Sharma was depriving Dr. Lin of a property interest in that authorship. I suspect Appley may try to draw a dichotomy between that question, because it pertained to what's uncontested with the IP property that neither own outright, versus the defamation-related claims. We would contend that there is no such distinction here. If Dr. Sharma was in the scope of her employment in regards to the authorship dispute on 2022 JCI Insight manuscript, it's unclear how her speech concerning that dispute would be outside the scope of her employment. Both areas show a connection to her employment at MD Anderson.
And you're talking about the two areas, the communications with the journal and the communications with her colleagues dealing with the IP?
Separately, there wouldn't be a dispute there. I don't know that the nature of their property torts went to that fact, but in terms of the distinction between internal communications and the journal, we don't think there's a distinction there either. Lastly, I'll just briefly note that the amicus brief that MD Anderson filed, and every public university system in our state joined, notes that it's typical for this research, type of research to involve multiple participants. It's just the nature of it. 3 or more is the standard. It's inevitable that there will be disagreements between those parties about how to allocate the credit for that work. As the amicus brief notes, and as Dr. Sharma agrees, it is really best left to the universities to adjudicate disputes concerning their own intellectual property. This effectuates the purpose of the Election of Remedies Code in 101-106F, as the Franca Court noted, which is to discourage litigation involving governmental employees. And in the research area, field of employment, this type of thing will happen. MD Anderson attempted to reach a resolution, and this litigation has frustrated that attempt. If there are no further questions.
I do have just a quick comment. Do you want go ahead?
No, go ahead.
I believe I saw somewhere in the record that there was an informal mediation with MD Anderson at one point. You don't have to tell me now, but you can tell us maybe back on rebuttal. But would there be any efficacy, or would it be good at all to order the parties to mediation at this point?
In terms of mediation, I don't know that it was a legal mediation, and well, let me to pull back on that. There's no jurisdiction. So if Dr. Sharma is immune to these claims, MD Anderson's not a party. So Dr. Sharma retains immunity to these allegations. There wouldn't be anything jurisdictionally left to mediate. And MD Anderson, it's their decision on how to address that underlying dispute from their perspective. So I don't know that there would be use to a court-ordered mediation.
Understood.
So kind of going back to the same line of thinking on the question I had a few minutes ago, then why wouldn't it be left to MD Anderson to, sort of intercept these communications, or have a process whereby someone could come to a third party within MD Anderson to say, I believe this person is not crediting me appropriately with authorship, and that way it's someone else who goes rather than the person, and it's not so much a he said, she said with outside parties.
That could be one possible resolution. The record doesn't reflect whether or not there was that sort of formalized process. But in terms of whether that demonstrates or excludes this conduct from the scope of employment, it doesn't. I mean, I would contrast it with Kai v. Chin, which has since been withdrawn, but there that had to do with the application of employment policy in a sexual harassment investigation and how it intersected with a defamation claim. Here, there is no policy that required Dr. Sharma to do anything that formalized. Instead, the relevant policies just show why her employment and her actions served an interest of the institution, which was proper attribution.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Jacob Hadges, and I represent the appellee, Dr. Jamie Lynn, in the case at bar. I'm going to start by briefly addressing a couple points that were raised during appellant's argument, and then I'm going to shift primarily to talking about what appellant didn't address at all, which is the language of the statute that's actually at issue here. In short, we believe that the trial court properly denied Dr. Sharma's motion to dismiss for three key reasons. First, the Tort Claims Act does not apply to Dr. Lynn's claims against Dr. Sharma because the Tort Claims Act itself says it does not apply to the claims asserted. Second, construing the statute to mean the exact opposite of what it actually says raises grave constitutional concerns that Dr. Sharma simply papers over. And third, even setting aside the statutory and constitutional infirmities of Dr. Sharma's position, the trial court could have reasonably held, or there was legally sufficient evidence to support a finding by the trial court that Dr. Sharma was acting outside the course and scope of her employment with MD Anderson. I'm going to start with a couple of points that were raised in the oral argument. First, to respond to the declaratory judgment argument, Your Honors, 101.106F is clearly by its own terms not a grant of immunity. We can see this off of several things. First, it's not self-executing. If a court lacks if it is a grant of sovereign immunity, it would necessarily need to be self-executing, because that would mean that neither the trial court nor this court has jurisdiction over it. And as the Supreme Court of Texas has recently recognized and very much laid out in Ratway v. City of Brownsville, this court can do nothing else if it lacks jurisdiction other than identify its lack of jurisdiction and move no further. 101.106F is not self-executing. This case did not come before this court or before the trial court on a plea to the jurisdiction. It came on a motion to dismiss. that if if Dr. Sharma had chosen never to file, the case would have proceeded normally. This is further highlighted by several other provisions of the Tort Claims Act. Section 101.026 provides that individual immunity from tort damages continue to exist under the to the extent that the employee has individual immunity, notwithstanding any other provision in the chapter. That provision, Your Honors, would be completely superfluous if 101.106F grants governmental employees immunity in any situation sounding in tort. Why would the legislature need to include a provision specifically stating that other forms of immunity, such as official immunity, remain unaltered if 101.106F itself grants sovereign immunity?
Well, wouldn't, in this case, I suppose you're arguing that these actions by Dr. Sharma were outside of the course and scope of her employment, correct?
Eventually, Your Honor, but first and foremost, it's outside the scope of the Tort Claims Act itself.
Okay, so, and let me make sure I'm understanding this correctly. Don't we start from the position that the state and its employees enjoy sovereign immunity?
You start from the
immunity from suit, immunity from liability for damages.
Yes, sir.
Okay, so if we're starting there, then why would the subsection here need to be self-executing to protect sovereign immunity that's already there, but is only waived? So so the TTCA provides a waiver, and then there's exceptions to the waiver. But if we don't get to the waiver in the first place, then why does it need to be self-executing?
So, Your Honor, we need to draw a distinction here. We start from the presumption that the state is immune. The state has sovereign immunity. There are many instances where governmental employees share in the state's immunity, most notably when they're acting within the course and scope of their employment. However, it's well settled that the Supreme Court of Texas has long recognized that an individual employee, governmental employee, is still typically liable for their individual torts. That they don't automatically share in the state's immunity just by nature of their employment relationship. And if we can, if we jump into the statutory analysis, I think that'll flesh it out a little bit more. Before we do, in answer to your question, Justice Johnson, regarding the conversion claims, we have decided to non-suit those. The only reason that it's still in a live pleading is because the case was stayed pending appellate review.
Well, but if they still exist, then don't we have to address them? Or do you concede that they should be dismissed under F?
But we do concede they should be dismissed under F, which actually gets into a point that we'll get to in a little bit, and it's a key distinction between the conversion claim versus the defamation claims.
And that would apply to both the conversion and the theft liability?
Yes, Your Honor, for reasons that we'll get into shortly. And first, we need to take a step back and go back to the statute itself. This case is at its core a statutory construction case, which means that we begin where we must with the language of the statute itself. And the key to this case, Your Honors, is to apply the clear and unambiguous text of the Tort Claims Act as it was written by the legislature. And when we look at that clear and unambiguous text, we see that the legislature expressly excludes defamation claims from the Tort Claims Act. The Tort Claims Act does not apply to defamation claims for two independently sufficient reasons. First, Section 101.057 of the Tort Claims Act expressly states that this chapter does not apply to any claim arising out of any other intentional tort. Defamation is an intentional tort, thus the Tort Claims Act does not apply to defamation. And second, Section 101.021 of the Tort Claims Act provides that it only applies to claims that seek recovery for property damage, personal injury, and death. Defamation seeks recovery for reputational harm, not personal injury, not property damage, and not death. And that's a key distinction between a defamation claim and a conversion or theft liability claim, which seeks recovery for property damages.
But again, if we're starting from there's immunity and the TTCA provides a waiver of that immunity, then the fact that defamation isn't covered, doesn't that mean there is no waiver for defamation.
There's no waiver, Your Honor, but the important distinction here is that there's a two-step inquiry, and a close analysis of the Supreme Court of Texas's opinion, Frank versus Vasquez, makes this clear. There's two steps. First is, does a particular cause of action or claim arise in the Tort Claims Act? And second, if it does the Tort Claims Act waive immunity for that claim? This case fails that threshold question of does the claim arise in the Tort Claims Act, because the Tort Claims Act expressly does not apply to intentional torts, and it expressly does not apply for claims for reputational harm.
Do you have any case law that suggests that?
Yes, Your Honor. Franco versus Vasquez. Franco versus Vasquez follows this analysis. Franco versus Vasquez concerned a medical malpractice claim. Medical malpractice is a professional negligence claim. There's no real question that negligence causes of actions can arise in the Tort Claims Act.
Are you saying that Franca says that intentional torts do not fall under the Tort Claims Act prong of F?
No, Your Honor. Franco versus Vasquez wasn't an intentional tort cause of action. My point is that Franco versus Vasquez, when read carefully, shows that there's a two-prong analysis, or a two-step analysis here, of does the claim arise under the Tort Claims Act, and Franco recognizes that tort claims presumptively do, but here we have a tort that expressly does not, and that what Franco ultimately holds is the answer to the second question, the answer to the question that Justice Guerra has gone back to, of does the Tort Claims Act waive immunity for the claim, doesn't impact the answer to the first threshold question. Whether or not immunity is waived has no bearing under Franco versus Vasquez as to whether or not a cause of action or claim for relief arises in the Tort Claims Act.
How do you distinguish these facts from the facts in Fink? Because wasn't that also a defamation suit?
So, Your Honor, we distinguish Fink in a number of ways. First and foremost, the parties didn't dispute or didn't raise the question as to whether or not the particular defamation claim arose under the Tort Claims Act. Everyone just accepted it as a matter of course. In fact, Lavery is the exact same way. Everyone just accepted as a matter of course that the act applied to the claims asserted without any argument or analysis to the contrary. As this court's likely aware, courts don't decide issues that aren't presented to it. I couldn't tell you why no one presented in either Lavery before the Supreme Court of Texas or in Fink that there's a threshold question here that's being failed, right? The act itself says in two different independently sufficient ways that it doesn't apply to defamation claims. Nobody asked that question, so the court didn't answer it. So again, Dr. Sharma accepts as a matter of course that any tort claim arises under the Tort Claims Act, but the Supreme Court of Texas has repeatedly held that tort claims presumptively arise under the act, not that they necessarily do. And as this court has recognized, when a statute's language is clear and unambiguous, it's inappropriate to resort to rules of construction or extrinsic aids to construe language. That would include a common law judicial presumption, such as what's stated in Mission Consolidated United School District in Franklin versus Vasquez, that a tort claim presumptively arises under the Tort Claims Act. Also, as the Supreme Court of Texas has noted, if the case can be decided according to the statute itself, which it can here, it must be decided according to the statute itself. Your Honors, when we separate the textual wheat from the extra-textual chaff, this is a remarkably simple case. Dr. Lynn's claims against Dr. Sharma do not arise under the Tort Claims Act because the Tort Claims Act itself expressly states that it does not apply to intentional torts and does not apply to claims for reputational harm. Implying the statute as it's written, Your Honors, is important because reading the statute to mean the opposite of what it says raises grave constitutional concerns. We make this second argument mindful of this court's holding in Elias versus Griffith that held that applying 101.106F to dismiss does not violate the, when the Tort Claims Act itself doesn't waive immunity, doesn't violate the open courts provision. However, we would like to I'll make it briefly to preserve the argument both for potential en banc review and then Supreme Court of Texas. And that is that if the election remedy provision operates the way that Dr. Sharma argues it does, i.e. that the tort claims, every tort claim arises under the Tort Claims Act, even if the Tort Claims Act itself says it does not apply to that claim, then a government employee tortfeasor is always able to dismiss claims against them in their individual capacity, irrespective of what the statute says. And then in situations where the state has not, where the Tort Claims Act doesn't waive immunity for the particular claim, such as claims that the Tort Claims Act expressly does not address, does not apply to, the state's always able to dismiss the suit asserted against it, citing sovereign immunity. And the result of this is that Texans' well-settled common law rights would get arbitrarily denied. Your Honors, even setting aside, however, the statutory infirmity of Dr. Sharma's position, even setting aside the grave constitutional concerns that get raised when you read a statute to mean the opposite of what it says, the trial court did not err because in denying Dr. Sharma's motion to dismiss, because there is legally sufficient evidence that Dr. Sharma was acting outside the course and scope of her employment. To this end, it's important to remember the procedural posture for which this case is presented. This case comes before the court from a trial court order denying a motion to dismiss that did not state its grounds. As the court is well aware, when a trial court order does not state its grounds for denying relief or granting relief for that matter, we presume that we affirm it if any grounds presented below would support the order or the judgment. And here, one of the grounds presented below was that Dr. Sharma was acting outside, or that there's a fact issue that Dr. Sharma was acting outside the course and scope of her employment with MD Anderson. Thus, this court can only overturn here today if it determines that Dr. Sharma has conclusively established that no reasonable jury could find that she acted outside the course and scope of her employment. Otherwise, this court must affirm, because that is a grounds that could support the trial court's order. The evidence here is legally sufficient that Dr. Sharma acted outside the course and scope of her employment with MD Anderson when she made misrepresentations to third parties outside the MD Anderson organization.
Which third parties are those? The two journals?
The two academic journals, yes, Your Honor. So the Tort Claims Act, it's important to remember, is a statute that waives immunity. It doesn't create substantive rights. So it naturally and necessarily follows that the state and its governmental subunits cannot be liable under the Tort Claims Act if a similarly situated private employer would not be liable for the same conduct. This is important here because Texas jurisprudence firmly disfavors finding employers liable for defamatory comments their employees make. There's two key cases here. One is Minyard Food Stores Inc. versus Goodman, Supreme Court of Texas case, and the other one is the Kyrie Chen opinion from this court's sister court that my opposing counsel had mentioned earlier. Minyard Food Stores recognized an employee's act must be in furtherance of the employer's business, and that one concerned allegedly defamatory statements made during a employee misconduct investigation. The Supreme Court of Texas held that defamatory statements made during workplace misconduct internal investigation did not further the employer's business, and this makes conceptual sense. If the employer is conducting an internal investigation, they're trying to get the truth. A defamation claim requires proof that the statement was false, a false statement. So lying during an internal investigation cannot further your employer's business interests. Kyrie Chen, interestingly enough, also concerned to MD Anderson employees asserting defamation claim and defamation claims, also related to like an internal investigation that MD Anderson conducted. The Chen court didn't go quite as far as Minyard Food Stores. The Chen court kind of divided the statements challenged into two buckets. One was those that were made as part of the MD Anderson's internal investigation, and the other were statements that were made kind of outside the scope of the investigation or the contours of the investigation, to other employees. And the 14th District noted that defamatory statements made to other employees are not made as part of the job functions merely because they're done at work, and that as such, dismissing defamation claims under 101.106F for those particular statements was improper.
What about as to the investigation?
What was that, Your Honor?
What about the statements made during the investigation?
Kai versus Chen held that the statements made as part of the investigation were part of within the course and scope.
Dismissible under F.
And it did dismiss those portions of the claims. There's tension there between Kai versus Chen and Minyard Food Stores. Kai versus Chen, the Kai versus Chen court relied on a 14th district, previous holding of the 14th district court that basically any statement made as part of a sexual harassment complaint needs to be within kind of work, the course and scope of employment.
Are there two buckets of communications that the defamation claims are based on? That being the communications made to the journals, and then the email and communications made to the colleagues?
Your Honor, here there's three buckets.
Okay.
Two of them are the exact same as was in Kai v. Chen, and the third is even further removed. The first is the statements that Dr. Sharma would have made, defamatory statements in our view, as part of the authorship investigation. Kai versus Chen would indicate that those are within course and scope. That's in tension with Minyard Food Stores. Second are defamatory statements she's made unrelated to the authorship dispute about Dr. Lin in like two other MD Anderson employees.
What would those statements be?
She has attacked our client's academic integrity, which is a pretty big deal.
Is that not connected to what Dr. Sharma believes is a theft of attribution?
In my opinion, Your Honor, it's starting to get tenuous. Ultimately, there are statements that she made outside the MD Anderson organization to research journals before MD Anderson had instituted a formal authorship review that again directly attacked our client's intellectual integrity. And those fall even outside of Kai versus
What
Chen.
statements were those specifically?
So there is Your Honor, I see that I'm running out of time. May I briefly answer you, please?
Of course.
Okay. So the first one was approximately 14 months before MD Anderson had begun its authorship review. Statements to a journal indicating that these are under review. She's not providing. Dr. Lin is improperly excluding authorship credit and attacking her intellectual integrity.
I guess that's my point. Is how did she attack her intellectual? Did she say she's not very smart? What did she say?
She was saying that she was improperly denying authorship credit. And then the second one was directly, the concerns that we have with Dr. Lin raised in our view a intellectual integrity issue. And Your Honor, that's important because in the research academic field, an attack on intellectual integrity can be a death knell in someone's professional reputation. In short, Your Honors, any way the court decides to frame the issues, be it looking strictly at the statute itself, which we would advance the court must do, or looking at the course and scope of employment, the trial court did not err in denying Dr. Sharma's motion to dismiss. For these reasons, we respectfully request that the court affirm. Thank you.
Thank you.
A few points on rebuttal, Your Honors. First on the issue of course and scope and some of the points that were just made. Concerning the communication Sharma engaged in with the third parties, all those emails, whether to CIR or JCI Insight, was to alert that there would be an investigation. They were hitting pause on the publication. The CIR manuscript in particular, as a corresponding author, she already had that express authority. And then it was implied directly into the JCI Insight when it was determined by Sharma and Drs. Diab and Abidaya that was a clear outgrowth of the exact same journal work, which MD Anderson has since substantiated. So that also goes to furthering the interest of the institution regarding work product of its employees. Regarding some of the relevant cases, Kai v. Chen as well as Minyard, as I alluded to earlier, that had to do with the application of a very specific policy that doesn't involve work product. It involves how to report and when reporting sexual harassment relates to one's employment. It's very unique and different from other cases this court has heard, such as Elias, which was also a defamation claim, where the employee of the city accused the plaintiff of lying in an open meeting, and that was the basis of that allegation, which this court ultimately held was within the general scope of that defendant's employment. Or Farabee, involving the allegations with that law office, also defamation, also was within the general scope of that city employee's employment. So the facts here for general scope all relate to work product and the communications to that topic. So that would be the main distinguishing feature between the Kai and Minier case. Regarding the brought under prong, just briefly, because we do think the case law is very clear on this, I think counsel may have misstated what the elements are about when something is under the Tort Claims Act. In Franca, as this court recognized in Fink, it's under the Tort Claims Act if one, it sounds in tort, and two, there's not a separate statute waiving immunity. In Fink in particular, while I think the general tort fraud claims may not have been contested, there was also a securities claim based on the securities statute. And the question that was addressed by this court there was, did that separate claim fall under the Texas Tort Claims Act for purposes of F? Even though there was a separate statutory provision independent from the Tort Claims Act, this court said yes, because the nature of the claim still sounded in tort. That demonstrates the breadth of the brought under provision of the Tort Claims Act. If it sounds in tort and there's not a separate waiver, it falls under the Tort Claims Act for purposes of F. Lastly, I'm not sure about the relevance of whether the F is self-effectuating or not. Official immunity, judicial immunity, qualified immunities, I don't believe are self-effectuating, but they're jurisdictional questions that can be raised through jurisdictional evidence that is common, and that's what's happened here. It's still a jurisdictional question, and when presented with jurisdictional evidence, not unlike pleas to the jurisdiction that are regularly filed on behalf of evidentiary pleas that are filed on behalf of state agencies, the court looks at that evidence, treats it like a summary judgment, and determines, is there a dispute of material fact concerning the jurisdictional question? We don't reach the merits of the allegations. So here, if we were to reach the merits, it would require a mini trial every time there's an allegation of defamation, slander, libel. We don't reach that question. In conclusion, Your Honor, all of the allegations against Dr. Sharma relate to her employment for a function that she did and others like her do every day relating to research that they perform at MD Anderson, UT Southwestern, Dell, any of the other state institutions. Unfortunately, a dispute arose here. And rather than going through or accepting the process, which aptly pled in her first amended petition that she did go through a process, she took her dissatisfaction and turned it into litigation. This is contrary to the legislative intent of 101-106. For these reasons, we would request that this court reverse and render judgment in Dr. Sharma's favor. Thank you.
Thank you. You have your arguments. This court is now adjourned.
All right.